Welcome everyone to our webinar on sexual harassment and bullying, your new duties under the workplace laws. My name is Joel Hayden and I'm a practice leader in LegalVision's employment team, and I'm joined today by my colleague Amelia Diskoros, who is a lawyer in the same team. Before we get stuck into this webinar, a couple of quick housekeeping items. You will be emailed the recording and slides of this webinar, so don't feel like you need to be furiously writing notes. You can also submit any questions that you have in the chat box and we'll try to get to them all at the end of the presentation. We would also really appreciate it if you could complete the survey that pops up after the webinar. We do value your feedback a lot. All attendees are also eligible to receive a free consultation with us to discuss how we can help you with any of your legal needs. To request that consultation, just provide us with your contact details in the survey that appears at the end of the webinar. So today, we're going to be discussing the recent changes to the Fair Work Act, the Sex Discrimination Act, and the Work Health and Safety legislation, primarily in relation to sexual harassment and discrimination, and to a lesser extent, bullying. What the new obligations and risks are. And as you can see in our agenda there for today, we'll be looking at that practically as well, and moving into some Q&A at the end of the presentation. Amelia will kick us off with an understanding of what sexual harassment is, and a breakdown of the new laws introduced in relation to it, which will also have some relevance to other misconduct in the workplace, such as bullying. Thanks, Amelia.
Thanks, Joel. Let's start by outlining the definition of sexual harassment as presently found under the Sex Discrimination Act. A person sexually harasses another person if the person makes an unwelcome sexual advance or an unwelcome request for sexual favors to the person harassed, or engages in other unwelcome conduct of a sexual nature in relation to the person harassed, in circumstances in which a reasonable person, having regard to all of the circumstances, would have anticipated the possibility that the person harassed would be offended, humiliated, or intimidated. Examples of sexual harassment in the workplace include inappropriate physical contact, such as unwelcome touching, staring or leering, a suggestive comment or joke, a sexually explicit picture or poster, and an unwanted invitation to go out on a date. The Secure Jobs Better Pay Amendment inserts new provisions in the Fair Work Act under a new Part 3 to 5A, which make it unlawful for the first person to sexually harass a second person, where the first person is a worker in a business or undertaking, a person seeking to become a worker in a particular business or undertaking, for example, a prospective worker, a person conducting a business or undertaking, which we will refer to moving forward as PCBU, and the harassment occurs in connection with the second person where they are captured by any of the categories I've just mentioned. Changes give individuals who have been sexually harassed in connection with work various options for recourse. Specifically, where a person alleges that they have been sexually harassed in connection with work under the amendments, they or a union may apply to the Fair Work Commission to deal with the dispute under a new dispute resolution framework modelled on the existing dispute resolution framework mechanism for general protections disputes under the Fair Work Act. Other amendments to the Fair Work Act include a vicarious liability provision modelled on the Sex Discrimination Act, which makes a person liable for the acts of their employees or agents, and ability to make joint applications. So the new provisions would provide flexibility for applications to be made jointly by individuals against one or more perpetrators, and would enable unions to represent one or more individuals. And there's also been a time limit of 24 months introduced after the contravention or last contravention to bring an application to the Fair Work Commission to deal with a sexual harassment dispute. This is consistent with the time limits that apply to complaints relating to the Sex Discrimination Act as well. There have also been amendments to the Sex Discrimination Act which aim to eliminate sexual harassment in the workplace. Specifically, a new Part IIA introduces a positive duty that requires an employer to take reasonable and proportionate measures to eliminate, as far as practicable, conduct which includes sexual harassment being unwelcome conduct of a sexual nature, harassment on the ground of sex, which is conduct based on the sex of a person, but not necessarily sexual conduct, discrimination on the ground of a person's sex, which is, of course, differential treatment based on the sex of a person, conduct that subjects a person to a hostile workplace environment on the ground of sex. So this would be conduct that results in an offensive, intimidating, and humiliating environment for people of one sex, but not necessarily directed at a person, and acts of victimization as a result of making those relevant complaints. Importantly, the positive duty applies not only to employers in respect of their employees, but to all PCBUs in respect of workers in the relevant business or undertaking. This extends the application of the duty to all organisations that conduct a business or undertaking, which would include companies, unincorporated bodies or associations, not-for-profits, whether you're an employee, contractor, trainee, volunteer, and even third parties like clients and suppliers. The positive duty will now apply to you. The definition of harassment on the ground of sex under the Sex Discrimination Act has also been amended so that there is no longer a requirement for the alleged wrongdoer to have engaged in unwelcome conduct of a seriously demeaning nature. All that is required now is that the unwelcome conduct was of a demeaning nature. This lowers the threshold for a finding of harassment on the ground of sex. The prohibition also captures harassing conduct that is engaged in by reason of someone's sex, but is not necessarily sexual. For example, a comment that one sex is stronger or weaker than another, or has particular strengths or weaknesses. Finally, in September 2022, the New South Wales government amended the Work Health and Safety Regulation, which introduced a requirement that PCBUs manage psychosocial risks in accordance with the risk management provisions of the Work Health and Safety Regulation, and specifies factors that a PCBU must consider when deciding which controls to implement. The amendments to the New South Wales legislation are going to be largely mirrored in other states. The changes to the model WHS regulation include defining psychosocial hazards as hazards that may cause psychological harm and that arise from design or management of work, the work environment, plant, or interactions or behaviours at the workplace. The changes have also established a separate process for controlling the risks posed by psychosocial hazards that is distinct from the hierarchy of controls. For example, redesigning, reorganizing, and supporting work, as well as modifying the work design, layout, and environmental conditions. Now I'll hand over to Joel to discuss employers' obligations and the risks associated with these amendments for employers.
Thank you for that rundown, Amelia. And now that we've considered the actual amendments to the relevant legislation, we need to address what are the new obligations that these laws have created and what are the primary risks that flow from them. Now, from what Amelia said, it's abundantly clear that these changes provide significant new protections and potential claims for employees, and really represent a shift towards addressing not just physical risk and harm in the workplace, but psychosocial risks as well. The new responsibilities for employers really cannot be understated and will need to be addressed by all employers in Australia. Now, paramount among these new obligations is the positive duty for employers to take reasonable and proportionate measures to eliminate sex discrimination, including harassment and victimisation. And what we mean by a positive obligation is that the amendments to both the Fair Work Act and the Sex Discrimination Act signal a change in legislative policy towards an employer needing to be proactive in preventing sexual harassment in the workplace. It's very clear it's no longer good enough to be reactive as issues of this nature arise. It can now be a contravention of the legislation where positive steps are not taken to prevent sex discrimination occurring in the first place. This will represent a real need for many employers to shift the way they think about dealing with sex discrimination and harassment, from perhaps having a written policy in a drawer somewhere and putting out spot fires as they arise, to really taking substantive steps to address these risks in the workplace before any actual incidents occur. We will address what those positive steps could look like a little bit later on in the presentation. It's also very clear that there is going to be an increase in employee claims and litigation as a result of these changes in the law. And this is for a few different reasons, being that the actual implementation of new courses of action, such as under the Fair Work Act in relation to sexual harassment, these claims are actionable and compensable for employees and can be pursued by unions on their behalf, as Amelia mentioned. And this significantly beefs up the options for an aggrieved employee under the Fair Work Act, when previously there was only very limited stop sexual harassment orders that could be sought, which were largely toothless and could not actually result in compensation being payable to an employee. Further, this jurisdiction will operate in a similar manner to the current general protections jurisdiction, and so will be a very familiar process for applicant legal representatives and unions, and a simpler process than proceeding under discrimination legislation. Similarly, the new cause of action under the Sex Discrimination Act, which now provides a claim for employees in relation to workplaces that are hostile on the ground of sex, it's a provision designed to capture broader conduct than the prior protections in relation to sex discrimination and harassment. And so naturally, this will open the door for a broader range of claims to be made and for employees to have success in those claims. This is a real lowering of the bar for what an employee can pursue under the Sex Discrimination Act and will have obvious implications. The limitation period for making relevant claims under the Fair Work Act and Sex Discrimination Act has also been extended from 6 months to 24 months. This will obviously result in claims that may not have been previously made due to delay by employees being made moving forward, and represent significant difficulty to employers. Responding to historic claims is more difficult than responding to recent ones, which are hard enough to deal with in and of themselves. So we would be really surprised if these circumstances and changes did not lead to a significant increase in claims made by employees. And putting aside the actual options for employees, the new laws also significantly empower the Fair Work Ombudsman and the Australian Human Rights Commission's regulatory functions in relation to sex discrimination and harassment, and enforcing compliance in relation to the new laws, including that positive duty to take reasonable and proportionate measures to eliminate sex discrimination in the workplace. The Australian Human Rights Commission will now have the power to ensure compliance in relation to the positive duty under the Sex Discrimination Act, and can conduct investigations and inquiries, make recommendations to employers, issue compliance notices, and make court applications to seek compliance with their purpose. The Australian Human Rights Commission has also been granted more general powers to inquire into any matters that may relate to systemic unlawful discrimination. Similarly, while the Fair Work Ombudsman has always had investigatory and regulatory functions in relation to enforcing compliance with the Fair Work Act, this has now been extended to allow the Fair Work Ombudsman to make applications to the federal court in relation to the prohibition on sexual harassment in the workplace, with this also being a civil remedy provision of the Act. What this means is that there's potential penalties up to $82,500 for corporations where they breach that obligation, and $16,500 for individuals involved in the contravention, and that could be HR managers, directors, etc. It can affect individuals in their own capacity. The relevant state WHS regulators will of course retain their usual powers to enforce compliance in relation to safety in the workplace, with this now extending to specifically include psychosocial risks in the workplace, such as bullying and harassment. These are significant new obligations and risks for all employers in Australia, and so Amelia is now going to begin addressing how businesses can look to practically address these changes.
Thanks, Joel. So where we have landed is that new laws place significant obligations on employers and establish many avenues for an employee to pursue claims against their employers. And there will be increased regulatory scrutiny and powers in relation to these matters. The combination of obligations and risks means it's absolutely vital for all employers to make practical and effective changes in their workplace to address risks to their employees relating to sex discrimination, harassment, and psychosocial risks in the workplace. So, it's reasonable and proportionate for one business may be very different to another. And so practically addressing these changes will necessarily depend on the nature of business, including its size and the industry it operates in. The explanatory memorandum to the amendments to the Fair Work Act is quite helpful in providing some illustrative examples as to what may amount to being reasonable and proportionate based on the size and nature of a business. For a small business of, say, around 5 to 10 employees, steps such as implementing a policy in relation to discrimination, discussing this with staff, and checking in on staff regularly is likely to be sufficient. Noting, though, that the policy must be implemented properly and communicated to employees. As mentioned earlier, it can't just be a piece of paper in a drawer. For a medium-sized business, say of around 50 employees, the implementation of a policy addressing specific risks based on the nature of the business and industry, specific training for management on a regular basis, and managers being responsible for monitoring and addressing the behaviour of their teams is likely to be sufficient. For a larger, more sophisticated business, think of at least a few hundred employees. The steps that should be taken should be part of a broad action plan that could include the implementation of specific policies that are maintained and updated regularly and accompanied by mandatory training for all employees. The collection and analysis of data relating to relevant surveys and complaints and access to resources, such as an employee assistance program to ensure employees are supported, are all steps that a larger, more sophisticated business should take. Explanatory memorandum makes obvious, and this is relevant to the changes to the Sex Discrimination Act and work health and safety legislation as well, is that there is essentially a sliding scale of what will be considered reasonable and proportionate for a business based on its size, sophistication, and the nature of the industry that it operates in. Where a business is on the larger end, is sophisticated, or operates in an industry where there are obvious risks that should be addressed, this will elevate what is considered to be reasonable and proportionate in relation to these new obligations.
So that leaves us with the question of, as far as the explanatory memorandum guidance is quite useful, what employers should actually consider implementing into their own business. And we strongly advise that employers should consider all options that may assist them in complying with those new obligations. As a general starting point, the following are our recommendations for how a business can approach compliance with the new positive duty and ongoing WHS duties moving forward. And that's to, number one, be aware of these new obligations, as well as the ongoing and expanded WHS obligations to do everything reasonably practicable to ensure safety in relation to both physical and psychosocial risks in the workplace. A business should then consider its size and sophistication, and in light of that, determine what is reasonable and proportionate, and whether there are certain risks in the business that may elevate this consideration, which could include, and remembering that these are just a few examples, work and client events where employees and those around them are consuming alcohol, employees who are working with limited supervision, vulnerable workers, and workers who will have direct contact and interactions with clients and suppliers. And as part of that process in identifying specific risks in the business, it is a good idea to consult with employees in relation to those risks and how they can be mitigated. The business can then move to considering what approaches and controls are currently in place and whether they need to be increased or adjusted as a result of these new obligations, and to implement any necessary changes, which may include policies in relation to matters such as sex discrimination, harassment and bullying, other WHS-related policies as needed based on the nature of the business, and ensuring that they're all maintained and properly communicated to workers. Developing an internal framework to comply with these obligations and general WHS obligations for management of the business. Ensure that there are appropriate and clear channels for workers to raise relevant issues and concerns. Conduct specific and regular training in relation to matters like sexual harassment, at least for management, and ideally for the entire organisation. And address any practices and procedures that may give rise to risk to the extent they can be mitigated, for example, through greater surveillance in the workplace, just as an option. These measures and strategies should then be monitored on an ongoing basis to determine their effectiveness and to ensure that the business is continuing to do what is reasonable and proportionate moving forward, and otherwise complying with their other WHS obligations. So this concludes the substantive portion of what we want to talk about today, and I'll now pass it back to Amelia, who will get to our questions and just wrap up our presentation. Thanks, Amelia.
Thanks, Joel. Yep, so that concludes the main part of our webinar. You might find our publication, the How to Hire and Inspire Guide, useful. You can download it via the handout section in the webinar panel. We also have an upcoming event that may be of interest to you. It's around managing employee sickness and absence on Thursday, the 27th of April, and the details are on the screen. You can also register at that link. We're going to be answering some of your questions shortly. While you submit them, we'll take a minute to tell you about our membership. So LegalVision's membership is a cost-effective alternative to expensive hourly rates you experience with other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document review, which includes drafting, amending, and reviewing business contracts and commercial leases. It also includes unlimited advice consultations with our team of over 100 specialist lawyers, including business structuring, employment, disputes, and more, as well as unlimited domestic trademark registration. LegalVision's membership is like having your own in-house counsel. We'll take care of all of your business as usual legal work, so you can focus on the running of your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. If you're an existing member, you can now add our WHS advisory service, which helps you comply with your work health and safety obligations. To learn more about how our membership can help you, request a free consultation when the survey appears at the end of the webinar. So now we'll answer some of your questions. Joel, I can see a good question here around, is it ever going to be reasonable for a business to not take any positive steps to prevent harassment and bullying?
It seems unlikely in most circumstances. If you've got any amount of employees that could engage in this conduct or be subject to this conduct, it's likely you're going to need to take steps to address these changes. Perhaps an exception to that would be very, very, very small companies. If you're a sole trader functionally working by yourself, you don't really need to give yourself a written policy to tell yourself what to do, because that's not very sensible. But if you have any employees, there is risk there, and so we would say take steps to address it.
Yeah, that makes sense. We've got another question that's asked that the presentation has mainly addressed what to do to prevent sexual harassment. What do we do as an employer if one of our employees actually makes a complaint of sexual harassment in our workplace?
And that's a great question. And the first point there is obviously to take it serious regardless of the circumstances it's raised in. But that doesn't mean that there's not an obligation on the business to actually get to the bottom of a complaint factually, so to speak. And so if allegations are made, it likely calls for an investigation. And that would be around talking to the complainant, understanding what the allegations are, and then addressing that with witnesses, addressing that with the respondent to the complaint, and actually reaching a conclusion as in the business's own eyes whether sexual harassment or discrimination, etc., has occurred. And obviously, if it's the view that it has occurred, it should be addressed. These investigations can be difficult, and it's not unusual for businesses to retain outside counsel and investigators to look into these matters. And so where there's complexity or cross lines with relationships internally that mean it's difficult to conduct that investigation internally, we do recommend retaining lawyers or investigators to assist with that.
Yeah. So we've also referred to discrimination on the ground of sex throughout the presentation. In this context, does sex mean gender?
That's right, Amelia. Sex means gender here. And there are, of course, a very wide variety of protected attributes under various discrimination legislation, as well as the Fair Work Act. Today, when we're referring to sex, we're specifically being referencing gender.
Okay, great. And our final question here is around our references in the context of work health and safety legislation. We mentioned the New South Wales government. How does that relate to national or other states?
Yeah, so the changes that we are talking about in relation to the Fair Work Act and the Sex Discrimination Act, they apply at the federal level. So that applies to employees in all states. We did mention specifically the New South Wales work health and safety legislation, just so we didn't have to mention every single state, but that's largely the same in every state except Victoria, who were just taking a bit more time to implement similar changes. So you can assume that what we've talked about will be relevant in all states.
Okay, sure. All right, we've got another question here. If a business finds that sexual harassment has occurred, is there an obligation on the business to report this to the Fair Work Commission?
No, there's not. And to be frank, the Fair Work Commission wouldn't actually want to hear about it. The Fair Work Commission is like a court, not a regulator. So while the Fair Work Commission will deal with proceedings in relation to sexual harassment to an extent, it's in their role as a third party who's impartial and, say, judging the case or assisting with conciliation or mediation. They're not the party that would actually investigate, or would they want to hear a report of this? So no, you would not be expected to report to the Fair Work Commission.
Okay, thanks for that. I've got another question. Is it ever going to be reasonable for a business to not take any positive steps to prevent harassment and bullying?
I think that one we may have just doubled up on, Amelia. That was the answer that rarely, if ever. If you're effectively just working by yourself, no, you wouldn't need to take any real step. If you have any employees, we would say, yes, you're going to need to take some steps.
Yep. Okay. All right, great. I think we've got one more. So most of the time when we get a complaint about bullying, both employees involved claim they are being bullied by the other. How do we deal with these type of he said, she said scenarios? Yeah,
and this is not an unusual situation by any means in relation to any misconduct in the workplace. You're often dealing with, conversations that people have had or discussions, and that equally goes for bullying. A lot of the way bullying occurs is verbally. And it's a similar answer to what I mentioned in relation to investigating sexual harassment issues as they pop up, in that the employer should be inquiring into these types of complaints. It's completely possible that where two parties have alleged bullying against each other, that either both are bullying each other, neither of them are bullying each other, or one or the other is. What's important is that the business factually gets to the bottom of it and determines what has occurred, so that if it does amount to bullying, proper steps can be taken to prevent it, and that could be issuing warnings, etc. But it would be following the employer reaching a conclusion as to what has actually factually occurred. Okay, well, that is all the time that we have for questions now. Thank you very much, everyone, for coming to the webinar today. And as we mentioned a little bit earlier on, we would really appreciate it if you could complete the 30-second survey that follows the webinar. Please also include your contact details to receive that complimentary consultation as well, including if you want to discuss how we can help you with your employment needs flowing from this presentation. Thank you very much for joining us, everyone. We hope you have a great day.
Thanks.